Hey, thanks for making it to Veterans Info Tap. I'm glad you made it. There is new landmark victories out there for veterans, and this was actually secured by the law firm CC&K. So good job for them. They have YouTube channel and so forth as well. And wanted to touch on this because this is a big deal for the veteran community. So with that, let's go ahead and jump into it though. Before we do, want to throw on a special thank you to Gregory Hargrove. Gregory Hargrove, thank you so much for the super comment, super chat thing. I really do appreciate your support so very much. All right, so jumping into this, CCK law secures landmark victory in Witkowski versus Collins. This court, the court overturns the Bowling versus Principe, it's hard to say, and restores board authority over extraschedular TDIU. That's a mouthful, but basically it puts the ability back into the board's authority to go with the extraschedular TDIU. Let's read into it here. They do have a nice piece written out here. Again, CC&K. You see them on YouTube. They're one of the bigger law firms out there for veterans. All right. So hit the thumbs up, subscribe, share with a friend, all that good stuff. I really appreciate it. Every thumbs up, every minute watched really does help the channel, and I do appreciate that support. So in October of 2025, the U.S. Court of Appeals for Veterans Claims. Now, let's just stop right there because a lot of folks don't understand the process. You file a claim. Maybe it comes back unfavorable. You have 3 decisions you could make at this point. A lot of changes that had happened over the course of the last 5 years. But your 3 choices are higher level review, supplemental review, or push it to the Board of Veterans Appeals. Those are your 3 choices if you have an unfavorable decision. Then let's just say you go HLR, higher level review. You cannot submit any additional evidence. You're assuming, I guess, that the VA has all of the information that they need to rule in your favor. Next would be supplemental claim. Now I'm going to supply additional evidence to support my claim. You do that, supplemental. Then let's just say that you did the supplemental and they come back and it's still unfavorable. Then you could push it to the Board of Veterans Appeals, the BVA, Board of Veterans Appeals. It's a veterans law judge there who will take a look at your circumstances. Now, the judge, could, and there's different, you can supply evidence, you can not supply evidence, you could ask for it, and all kinds of different things. But the bottom line is it's a veterans law judge. They can appeal it, or not appeal it, they can approve it, deny it, or remand it, which is push it back to the VA for more kind of like discovery. Now, let's say it comes back and it's unfavorable again. Then you push it to the U.S. Court of Appeals for Veterans Claims. So it's kind of like there's a lower court and a higher court, right? BVA is essentially the lower court, and then you would push it to the Court of Appeals for Veterans Claims. All right, so in October of 2025, the U.S. Court of Appeals for Veterans Claims issued a sweeping decision in Witkowski versus Collins. The ruling argued by CC&K, so they were the law firm that took it there, and it was attorney April Donahauer, overturns more than 20 years of precedent. That is a heck of an argument and a heck of a win. So it overturns more than 20 years of precedent and removes a major source of procedural delay for veterans seeking total disability based on individual unemployability. That's TDIU. Some people just say IU, some people say unemployability, and they do this, it's on an extraschedular basis. So the court explicitly overturned Bowling versus Principe, I don't even know how to say it, ending the long-standing requirement that Board of Veterans Appeals, so remember, upper court, lower court, that the Board of Veterans Appeals must first send extraschedular TDIU cases to the Director of Compensation before deciding them. For countless veterans, this change means faster decisions, fewer procedural dead ends, and a fairer path to benefits. Huge win for 100% payments out to veterans, which is very, very important when it comes to VA disability compensation. This case is also an example of CCK law's philosophy of systemic advocacy. Each case is prepared meticulously, and every argument is developed as though the case may one day be presented before a court. If a case exposes a recurring regulatory problem that harms tens of thousands of veterans, CCK aims to be ready to fix that problem, not only for an individual client, but for all veterans who rely on this system. Below is the breakdown of what happened in Witkowski, what the court held, and why the decision matters. So the background here: for more than 2 decades, Bowling, which was the previous decision, required the board to follow a rigid 2-step process for extraschedular TDIU. And what it makes me think of, 2 steps, just to segue real quick, is that was the same thing we had to do on the VHA side, the healthcare side, when it came to referral to community care. Not only did your doctor have to say, yes, good for community care, they had to get it approved by a second set of eyes above them that did not know who you were. So same thing here, second set of eyes. So moving on, if a veteran did not meet scheduler TDIU criteria, but evidence showed unemployability, so in other words, let's say you were 50% for migraines, and the evidence showed that you were unemployable due to your service-connected disability, the board had to refer the case to the Director of Compensation for an initial opinion. And then 2, only after the director issued a decision could the veteran return to the board for an appellate review. What a nightmare. In practice, this mandatory detour caused years, not months, years of delay. The director usually denied these referrals, and the process duplicated adjudication that the board could otherwise have completed in a fraction of the time. So you're just stuck in this hamster wheel. Veterans routinely waited several additional years after referral before the board could make a final decision. Under the AMA procedures, referral also forced many veterans to file a new notice of disagreement, sending the case back to the end of the appellate line. This system trapped veterans like Mr. Witkowski, a Vietnam-era Navy veteran seeking the earliest possible effective date for TDIU based on hearing loss. Although evidence showed unemployability from the date of his claim, the board believed that the Bowling decision, the one a couple decades ago, prevented it from granting TDIU before June 2021 without a referral. Remember the referral to the Director of Compensation. Because Mr. Witkowski explicitly waived referral and asked for a decision based purely on evidence, the board denied the earlier period outright, allowing the issue to be appealed to the Court of Appeals for Veterans Claims. The court, right? The U.S. Court of Appeals. So again, upper court, lower court. So this set the stage for the court to address the question about jurisdiction, regulatory interpretation, and procedural fairness. All right, so there's a couple different things that they want to point out here, so let's run through this. Only Congress can limit board jurisdiction. Okay, so CCK law argued that Bowling was inconsistent with modern Supreme Court jurisprudence, holding that only Congress may impose jurisdictional limits on an adjudicatory body like the Board of Veterans' Appeals, because Congress gave the board jurisdiction over, quote unquote, all questions in a matter under 38 U.S.C. 7104A. The board must be able to decide TDIU, including extraschedular TDIU, when a veteran appeals that issue. Therefore, an agency promulgated regulation like the one requiring referral of extraschedular TDIU cannot be jurisdictional. It's a lot of big words, but basically just saying like the court had the power, how could the VA step in and say that they have to somehow have a second set of eyes on that? The court agreed with CCK's law argument, so that's good. The next piece here is the regulatory text never applied to the board. Okay, so CCK Law also argued that the referral requirement never applied to the Board of Veterans' Appeals in the first place. The regulation at issue is 38 CFR 4.16b. It states rating boards should submit to the director all cases of veterans who are unemployable by reason of service-connected disabilities, but who fail to meet the percentage standards. Now, for those that don't know and are hanging on here, the VA has specific rating requirements for TDIU, total disability, individual unemployability. And even if you don't meet those rating requirements that you have, you could still get rated TDIU even with a lower rating. So as long as you show that your conditions are causing you the unemployability aspects. So in other words, do not self-segregate out of TDIU if you are in fact unemployable, you can't hold and maintain a steady job due to your disabilities that are service-connected, then you should absolutely go that route and give it a shot. CCK Law demonstrated that historically, rating boards were 3-member panels located within regional offices. The Board of Veterans' Appeals has always been a separate appellate tribunal. When VA intends to refer to the board, VA uses the term board explicitly in its regulations. Therefore, 4.16b reference to rating boards does not include the Board of Veterans' Appeals, meaning the board was never required to make these referrals. And that totally makes sense. And somehow, some way, somebody took the same word board. It's kind of like VSO, right? VSO could mean Veteran Service Organization, or it could mean Veteran Service Officer. So let's move on. The court's holding Bowling is overturned. Bowling versus Principipi, I don't even know how to say it, was wrong. The decision conflicted with later Supreme Court authority distinguishing jurisdictional rules from claim processing rules. The mandatory referral process cannot be imposed on the board because of the 4.16b, which was talking about the board or the rating board, right? Two separate things. Rating board internal to VA. The board is the actual Board of Veterans' Appeals. So why this decision matters for veterans? Number one, it makes this whole process, if you're going through appeal, okay, if you don't get it right the first time and you end up pushing it to the Board of Veterans' Appeals, it's going to make it be a much faster process because now they've taken away that second set of eye requirement, which was ridiculous. So faster decisions and elimination of mandatory referral delays. 2, it's greater consistency in TDIU outcomes, which is also great. Stronger access to judicial review and system-level impact beyond a single case. So that is all fantastic. If you are having any issues legally, right, with your VA claims, if you have, let's say, a Q, right? So many people have heard the term Q, C-U-E. It is clear, unmistakable error. If you have maybe a clear and unmistakable error, you definitely want to reach out to a law firm. If you're pushing it to the Board of Veterans' Appeals, or if the Board of Appeals has given you an unfavorable decision, you would probably also want to contact a law firm to take a look. Oftentimes it's a free consultation and they'll see if it's something that they can put together for you. So with that, thanks for watching. I appreciate you very much. Have a great one. And remember, if we don't take care of each other, something went wrong.